Hello, I'm Natalia Angelini.
And I'm Rebecca Rauws.
Welcome to Helen Estates. You're listening to episode number 531, and you're viewing episode 531 with us. Today we are going to be discussing a recent case dealing with a life insurance policy. In the case, it's going to be on our website, but it is Sun Life and Nelson Estate. It was decided just a few weeks ago. It's not a lengthy decision, it's a fairly brief endorsement, but it does touch on issues that we thought would be interesting to talk about today. Okay. So maybe we can just delve into the facts a little bit.
Sure. Okay, so the deceased in this case passed away in December 2009. She was married at the time of her death. She'd been married for about 3 years to a man named Justin. And she also had 2 daughters who were the respondents in this case. And the applicant was Sun Life, of course.
Right, and she died with a couple of insurance policies. One was a personal policy that is not an issue, and the other is a group policy that she had through work.
Right.
And that's the policy that is at issue.
Right.
Because, interestingly, she originally had designated Justin as the beneficiary, but then in 2007, just a couple of years before she died, her employer had switched insurers to Desjardins. So at that point, she'd filled out documentation changing the beneficiary designation to her 2 daughters. The twist was, and that was something that wasn't discovered until after she died, was that because she was disabled at that time, her policy remained with Sun Life. So she ultimately that ended up with 2 designations on file. She died in 2009, right? And she died leaving a will.
Yeah, she had a will. They gave to her spouse Justin personal household belongings, her car, some RSP benefits, and then the residue was to go to her 2 daughters equally. And then the will also included an insurance designation term that said that the insurance policy was to be held in a separate trust and dealt with as provided for with respect to the residue, so to her 2 daughters equally. But there was a bit of an issue because it said the insurance policy, and she owned 2.
Right. So it wasn't particularized, and we'll get into that in a minute. But then what happened is, so she passed away when her claim under the group policy was being processed. That's when they discovered that there were these 2 designations. And that her coverage had actually remained with Sun Life rather than being bumped over to Desjardins. And so as a result, 1 or 2 of the daughters, I think, had decided to go to Justin and ask him to sign an authorization relinquishing his interest, which he did, which was good of him to do so.
And right away it looks like she died in December 2009, and then by January 2010 he had signed that acknowledgement.
Right. That said, the monies were, a check was still sent to him.
Yeah, Sun Life ignored the acknowledgement, it looks like.
Right, and he tried unsuccessfully to return it, and then what Sun Life decided to do was to deposit the monies with the court. And I don't know what happened between 2010 and 2017, because we're now in 2017. And Justin never laid claim to the funds in all of those years. And I guess at some point Sun Life chose to commence this application and have the matter addressed with the court's assistance. The 2 issues being, number 1, is the insurance declaration in the will valid or not? And number 2, was the change of beneficiary designation valid or not? So maybe we can get into the first one and look at the will.
Yeah, so the court looked at the term in the will, and as I mentioned, it said the singular insurance policy, but these deceased had 2 policies. So in the Succession Law Reform Act, Section 51 sub 2 says that you can make a designation for an insurance policy or a plan in a will, but it's effective only if it relates expressly to the plan. So the court doesn't mention that provision of the Succession Law Reform Act in their decision, but they did decide that because that term, there was no indication as to which insurance policy it was referring to, they couldn't interpret it without more information, as it would rewrite the will and maybe alter the testator's wishes. So they said it was ambiguous and the term failed.
Right, and that even though it was before Justice Carol Brown, I believe, even though she didn't reference the SLRA, her decision is in line with the SLRA. So then that issue aside, then we turn to the issue of the beneficiary, the change in beneficiary designation. you know, it is noteworthy that in this case, it wasn't an opposed application. The husband, I think service was dispensed with.
Yeah,
His
I think so,
whereabouts
yeah.
were unknown. He'd already signed the acknowledgement, which I would suspect the court relied upon, or gave some weight to. The court did declare the change to be valid.
Yeah.
There was some other evidence before the court in that regard too.
Yeah, they also considered things that the deceased had told one of her daughters before she died, that she'd made financial arrangements for them. They took the form kind of at face value in that she didn't know that it hadn't been switched over, and she had intended to file it, so that was, I think, an important factor. And then also that Justin had signed that acknowledgement.
Right, and again, this aligns with the applicable section in the Insurance Act, which is section 171 sub 1, I believe, which essentially defines what a declaration is. And it is sufficient that it be in writing, that it identifies the policy and the person who is to benefit, and all those points were met. So, you know, all in all, it seems to be a fair and just outcome, and the daughters can at long last receive their money that they don't seem to, or maybe they weren't aggressively chasing, I don't know. A good decision. So, unless there's anything else you have maybe to comment on it?
Yeah, I think that pretty much covers it.
So I suppose that concludes our podcast. Until next time, we want to thank you for watching and for listening. I'm Natalia Angelini.
I'm Rebecca Rauws.
Should you have any questions, please email us at webmaster@hullandhull.com or leave a comment on our blog.